Let me present before you some of the important points in reference to the gift deed. So section 122 of Transfer of Property Act provides for the gift deed. The primary consideration of the gift deed is the gift so made as regards an immovable property or even to a movable property. The ownership has to be in full. So whatever being conveyed through a deed of a gift, the said ownership has to be absolute without any encumbrances. It must be his own. It must be the own property without any encumbrances of the donor. So this is the main consideration. For example, if it is an ancestral property, undivided property, then he cannot give that property, as his own, because still it is not partitioned. It does not stand in his name exclusively. There are encumbrances. Therefore, the primary quality of the gift has to be owned absolutely by the donor. This is primary thing. Secondly, the donee has to accept the gift. So the donor will gift it and the donee has to accept. So these are the two qualities that will make the gift deed complete. And when the gift deed is made by the class 1 heirs, that is between husband and wife, father, mother, children, then there is an exemption for the stamp duty. So if it is if the gift is made for any third party, gift can be made to anybody. It can be the gift when it is owned by a person, the owner of the property, the absolute owner of the property, he can gift his property to anybody. It is not necessary gift has to be amongst his own relatives. It can be to friends, it can be to anybody, any Tom, Dick and Harry. It can be to a trust, it can be to a charitable association. It can be gifted. However, when gift is made outside this class 1 heir, then the stamp duty has to be borne as per the value of the said property by the donee. Who is getting the gift, he has to pay the stamp duty. Just in the case of sale of transfer of immovable property, as applicable between the vendor and the purchaser. So these are the two differences when it is gift is made within his own clan, and if it is outside his class 1 heir, then this stamp duty is applicable. Section 17A of the Registration Act makes it mandatory that immovable property has to be registered and the stamp duty has to be paid if the gift is made for the third parties. And now the donor has to be in perfect senses. He must be in a position to take his own decision. And secondly, the donee who is accepting the gift has to be a major. He must have attained the legal age. In case if he is a minor, then the gift cannot be made. Gift can be made provided there is somebody, a power of attorney who can take care of the donee's property until he attains the legal age. So once he attains the legal age, then also the donee, the recipient of the gift, has to accept the gift. Only then, that too, he has to accept the gift within the lifetime of the donor. So only then the gift will become valid.